Welcome back. Thanks for staying with us on News at Prime. South African women have, over the years, made the country proud on the sports field. Just last month, Banyana Banyana won the Women Africa Cup of Nations title, leading to growing calls for equal pay for women in sports. More on this, we're joined by Molatudi Attorneys Managing Director, Osborne Molatudi. Very good evening to you. Thank you so much for your time. We saw the excitement around Banyana Banyana. I mean, there's also great strides here with a golfer, Ashley who has also done significantly well. And then at the end of the day, the question now comes under the spotlight on equality within sports. We heard President Cyril Ramaphosa as he welcomed Banyana Banyana at the Union building, speaking about the significance of women and their rights, saying that more will be done and they will indeed be compensated like they Bafana counterparts. But all of it really comes down to paper, doesn't it?
Indeed. And thank you, Paul, for having me on your show and to your viewers. Indeed, I think Banyana Banyana's achievement obviously sends out, a call that perhaps it's about time that there be what is referred to as equal pay for work of equal value. But this shouldn't even be seen as something that is emanating now. There's a constitution in our country in terms of Clause 9 that guarantees everyone has equality, that everyone is equal before the law and has to enjoy protection and benefit of the law. And secondly, you then have what we call enabling legislation. And one of the most common one is the Employment Equity Act, together with its regulations. And, all this make provision that there has to be an attempt by employers and various bodies to move towards, closing the pay gap between men and women, either in the workplace or in sports or anywhere for that matter. And by the way, that also extends to ownership, such that there will be more calls that we need to see more women owning some of the sports clubs, being in charge, having them as coaches, and while at the same time being rewarded in the same way as their male counterparts.
It's one thing to highlight Banyana Banyana and women in sports, but we know that in general, companies, several companies are already failing with employment equity when it comes to gender, race, and so forth. How then does this conversation get heightened to levels where the policy is taken seriously and something is done about it? Because, I mean, my salary is confidential and so is yours. So how would I know? Where do I gauge? How do I know as a woman of color? How would you gauge it?
I think that's a very important question, and that's the reason why some of the affected employees or women in sports or any other person for that matter sometimes be reluctant to bring about a grievance if he or she reasonably suspects that he or she is being underpaid. However, the laws are there to protect those employees who may wish to bring forward their grievances about that which they reasonably suspect that amounts to a pay disparity, in the sense that it also protects them against victimization. And that is why most employers, and in terms of our enabling laws, are encouraged to adopt policies that will promote equality, equal pay for work of equal value, including the regulations. I mean, if you open those regulations, anyone can read and understand them. It's up to us as employees, our representatives, to really take up these issues to the relevant person that are in charge of employee relations, human resources, to make sure that those policies are implemented to the letter. Like I said, the Constitution is there. It has, a very important Bill of Rights in the form of equality before the law. It has Section 23, which guarantees everyone a right to fair labor practice. You have the same repeated in our commonly known LRA, Labor Relations Act, Section 23, guarantees everyone. And it's from that premises that employees, women in particular, should not be afraid to lodge grievances or to raise concerns about any perceived or alleged pay disparities, and they need to do so within the bands of reasonableness and in terms of the employer's policies.
So how does, it's quite an interesting point that you raise, especially as we're in Women's Month. We're on the eve of Women's Day, and that in itself is a massive conversation when it comes to equal pay on gender. How then do we eliminate the process of unequal pay and then begin to have the confidence to come forward and raise your hand and still be able to do it backed by law and legislation?
I think the starting point is just a normal conversation between an employee and his or her supervisor. And in this sense, we're talking female employees, women in sports, you name it. So that's the starting point. That conversation should begin with the immediate supervisor. And in the case of Banyana Banyana, I would imagine it will start with the team manager, the coach, who will then perhaps take up the grievance with SAFA, and then even at the highest level possible, depending on the internal protocols that are available at SAFA. But in the workplace, it has to be that way. You start with your line supervisor, and then you escalate it up to the HR. And I need to emphasize that in the event that one is not satisfied with the resolution or an attempt to resolve that grievance lodged internally, we can still go to the outside bodies such as the CCMA, the bargaining council, or even the labor court if such complaint will be underlined by an allegation of discrimination.
Perhaps let's talk a little bit about the salary confidentiality clause. I mean, who does it really benefit? I mean, I understand how it averts chaos within different sectors and offices, but who is it essentially meant to benefit?
I think in a private sector, confidentiality can have certain limitations. But when you deal with public figures, like your Banyana Banyana players, when you deal with, public sector entities, when you deal with employers that have to compile employment equity reports, because in the employment equity reports, one of the sections that the employer needs to complete is what is referred to as pay differential. So you list the highest paid, middle, and to the lowest, and you have to explain why there is such a pay differentiation. But at the same time, you do have, the Protected Disclosures Act that will really protect anyone who wants to come out and say, I believe I'm underpaid, and therefore I want to exercise my right, not only in terms of the law, but in terms of your own policy, which says if I'm not satisfied with anything in the workplace, I'm entitled to lodge a grievance. And in that context, you can be protected. And by the way, when I mentioned the Protected Disclosures Act, is that you can even request information to say, I reasonably suspect that I'm earning less than my male counterpart, yet we do the same job. Can I have this information? So you can make a request for information and explain the reason why you need that information. Insofar as public sector or even the government, even outside bodies can assist those who are aggrieved by lodging the appropriate request for information with that employer. And it's from that premise that that employer will then be forced to entertain that grievance objectively and not subjectively. And again, as I said, if it's not resolved, the person is then entitled to go to the outside bodies such as the CCMA, bargaining council, or the labor court.
I mean, basing your argument, I mean, you speak about how you can perhaps approach an employer about trying to get a sense of the pay gap or finding and feeling that you may be earning less than your male counterpart, or whether be it on race and for the same job and the same skills and qualification. Is it healthy to base the bulk of your argument on hearsay? Because that in itself could, open up other potential charges about gossip and so forth and lead to a dismissal, surely.
I must question that will be a dangerous premise to move from. Don't lodge a grievance based on hearsay. Don't lodge a grievance based on corridor, what is referred to as corridor mongering, because in the end, you might prove that your grievance based on that hearsay evidence or gossip, it's unfounded. Rather get the facts first. As I said, you speak to your supervisor You know, they say, he who hides nothing fears nothing.
Yeah.
So if the employer knows that it treats its employees well, that employees who do work, same or similar work, etc., are rewarded almost in the similar band in terms of the salary assessment that they will have done with the experts, etc., that employer would not hesitate to share that information. In fact, our firm does advise some of our corporate clients on how to go about handling complaints against pay gaps and related. And the starting point being the employment equity report, because that obliges every employer to make such disclosures. And it's from that premise that trade unions, employees themselves, employee representatives can then make use of that information to then lodge a valid grievance if there is still evidence that there is a pay gap. So to act from gossip or hearsay, it might be challenging and dangerous for a particular employee. Rather gather your facts and then move on.
Yeah, very well. Thank you so much for some sound advice there. Molatudi Attorneys Managing Director, Osborne Molatudi, speaking to us there about how to raise your grievance should you feel that there is inequality when it comes to the pay gap.